Are you worried about how the new USCIS adjustment of status memo impacts your status as an immigrant? Immigration attorney Pallavi Ahluwalia is going to share some practical advice to help you navigate the changes.
On May 22nd, USCIS announced the Policy Memorandum, which is 602-0199, formally reframing the adjustment of status to be a matter of discretion and grace rather than the right that everyone else had assumed that it was. And this has impacted foreign nationals who've stayed here, build their careers here, they've gone to school here, paid taxes, they've maintained lawful status, and they thought the end result of all of that would get them the much prized green card in the United States. So this has upended that understanding, and this understanding, which has been in place from I'd like to say 1952, and then has been reconfirmed by the government by several memos over the years. So it was not a random assumption. It has been stated the conditions for, say, for example, maintaining your status under 245K, and if you're employment-based employee, how to be eligible for 245K. Then the 485J under AC21 alignment, which says that if you have a 485 pending for over 6 months and your I-140 is approved, you can move on to another employer. So there's at many steps that the government has confirmed the understanding of an adjustment of status, which is right now being questioned, and a new policy that is replacing that old understanding.
What should B1, B2 visa holders looking to adjust within the country know?
So, see, when you go for a B1, B2 stamping, or when you enter the country on a B1, B2, you're stating the government your intent to be here on a temporary basis, number one. Number two, you're telling them that you actually will not stay back here because you have financial strength in your home country and you have emotional ties back to your home country. That is the premise that underlies a B1, B2, as well as an F-1, which the premise of being here gets replaced by just visiting to coming here to study. So those are the intents that are assumed for you when you come here on a B1, B2, or I've also now included the F1 in this discussion.
What about the F1 or STEM OPT status holders? Should they wait to adjust status? What about the ones who have already filed for adjustment?
Okay, so if you've already filed your adjustment, I would say you can't do anything about it, right? We do have a suggestion that you could trigger if your I-130 or your I-140 had the choice of adjustment of status, and if the government to be really harsh at your interview, then you do trigger an 824 right now and send the case abroad. But there are two more things that we'd like to point out to, and one is maintain your status underlying, right, for right now. And if you call for an interview and they say that why in this matter should we exercise our administrative grace in your favor and grant you an adjustment, then you should have a litany of things that you've done to help the country, meaning you've contributed to your employers in XYZ manner. If you have a US citizen spouse or a green card holder spouse, that you're here and that spouse is here, it's impossible for that spouse to make their journey back to the home country to wait this out with you. So a list of positive factors that the government should use to exercise their discretion on your behalf, right? So you should have that list that you would go prepared with. But at the meantime, if the government were to start being harsh and take away that adjustment or have you fall on nothing, at least trigger your 824s, which is an action on approved case that you send out to the government. And that way your file, which is an I-130 approved file or an I-140 approved file, now it only applies to approved cases, that could be sent to the consulate. So the worst case scenario, you have that lined up for you while you're still fighting the matter here in the US.
While still on the subject of F-1 and STEM OPT status holders, aren't the anticipated changes coming in September 2026 an even bigger concern, especially in regards to duration of stay?
So, the immigrant to get past the immigrant intent for people who used to come in to the country and were given D/S, which is duration of status, we would say, okay, you can be here. Maybe earlier it used to be 60 days and we made it 90 days and we stuck to 90 days from your last entry into the country. But now this is what's going to happen. It's going to be per semester or maybe for the length of the course. If you are on maybe a program that gets your degree finished in 1 year, then you'll have it just for that 1 year. And if you're just studying something or, just doing something that's a little bit more short-lived, then it may last only till the length of your course that you're undertaking. So yes, it's definitely going to impact. Will lawyers right now be telling students or visitors to not file an adjustment? I don't think so. We'd say, do not file an adjustment. Do not file, file your I-130s, file your I-140s, but make it a two-step process, which we call is to move the second step to the NVC and do your consular processing at NVC. Now, for these folks, you have to make sure that there are no other critical factors that may impact you returning back to the US and that you will have a good adjudication. Now, us telling you to mark as such is not telling you to leave the country yet. We're not saying that. We're just telling you to mark your I-130s with consular processing. Don't file an adjustment just yet if you're on single intent visas, and just hang in there for a bit and let's see how this plays out. If you have an I-140 or I-130 approved, file your A24s. Don't leave the country yet again, right? Because if this changes or gets legally challenged by courts and it's reinstated as the law of the land that it should be, then we will see how even with that marking, you can file your adjustment of status at that point and you should get covered.
For those currently on employment-based visas, like the H-1B, L-1, or O-1 who want to move towards permanent residency, how should they prepare for it now?
Well, for them, I think they may have a list of positive factors that do impact them. If they've maintained their status, just if they want to be safe, they can still mark consular processing, right? And keep moving this on. But, and when time comes, start the NVC process and then we see how it plays out. But if they've already filed their adjustments, I think they may have a list of positive factors and then we'll need some data to be able to for sure tell people how to run this, right? Because at this time, because it's a new announcement from May 22nd, we have to see how it plays out and who goes to court and who doesn't go to court and what happens.
And for those who may not know what the distinction is, could you explain the difference between single and dual intent visas?
A single intent has the singular purpose that you're being given that visa for, which means that you come here to visit, or you come here to go to school, or you come here and you're here only as a performer, or you come here as an investor, and that's it. You have just those intents. There's some visas that allow you to morph into a different intent. So if you're an H-1B, you've also told the government that you want to work here, and maybe that may convert into long-time work. So that makes it dual intent. But the L1s, that's the same assumption that underlies. So, so those are obviously the more prevalent visas. So we had a lot of people, this is just a point that I'm making to some clients that gave pushbacks to everyone that said, okay, you know what, I can just maintain my F-1 status. I don't have to do much here. I'll keep going to school. I'll keep on going from one degree course to another. I can stay on another master's, a third master's, whatever it is. And I will have my employer just file for a green card. And of course, this does not apply to Indian nationals who have a long line or Chinese nationals who have a long line. But say, for example, people from Nepal, from Bangladesh, from Pakistan, and I'm talking, or Sri Lanka, and I'm talking about the South Asian diaspora, but this could also apply equally well to anybody from Europe, who is not backlogged severely in the visa bulletin. And their plan was, okay, I'll be a student and then somebody will get a green card done for me. I'll remain working under my curriculum practical training or my STEM OPT, and I'll get my green card and I should be okay. Well, that's not a good plan anymore. It never was earlier as well, because there was an intent interference, right? But people again did not take that seriously. Now that it's out here in black and white, you can understand that the intent of your visa does matter. So you moving on to your next status, which is the H-1, would be something that you should follow if you want to apply for the adjustment here. Or then as a student, you stay here and then you take the challenge of going abroad, doing the counselor process through the National Visa Center, doing your interview, and then coming back into the country. And that's how you run this.
And lastly, what is your message to the thousands of anxious immigrants navigating recent changes to the system?
So if you're present in a dual intent visa that was designed to accommodate immigrant intent, you should just make a list of positive factors that impacts you and then stick with that. If you were to keep filing what you're doing, and then we'll see how this plays out. Now for the others who are the single intent, I would be worried for you. So I would say that if you have something, even if you have an adjustment pending, kindly do file your action on an approved case, right, and file your A24s. Meanwhile, next lottery season, literally may the luck be with you and you get selected in the lottery and keep moving on with your employers and get to the other side. But for right now, just overall view, let it play out, right? Let the whole thing play out and see where it falls. But don't sit, always keep taking action, right? Keep moving to your next thing to do. And that's what you can do as an immigrant in the country. Keep your status, understand the intent that impacts you, and do the next thing that we've already given you advice for. Thank you, and all the best to everyone.
If someone you know would benefit from this information, share this video with them. And if this was the general advice you were looking for, like this video, subscribe to our channel and hit the bell icon to be notified of our uploads. Thanks for watching. We will see you all in the next one.